Well, at the moment, you would have seen many stories in the past week or two where we're really grappling as a nation with this idea of what makes a parent a parent. Now, this is on the back of a very landmark case, which we will describe in a moment. But it's also expanded now in talks with things like a potential egg bank, sperm donor rights, and all those sort of broader topics associated with it. But if you were to define what makes a parent, what do you think that would be? Is it biology? Is it intention? Is it something else? Well, as I said, this is something the law is grappling with, and here in South Australia, that is being done as well by my next guest. Troy Roulstone is an associate solicitor from Anderson's Solicitors. Welcome, Troy.
Thank you so much, Sonia.
I'm actually surprised that we don't already have a definition in the Family Law Act as to what a parent is.
Yeah, it
feels like the horse is bolted already.
Well, that's right. I mean, I think it's important to recognise that there are presumptions about parentage in the Family Law Act, and that discusses things like whether the mother of a child born has a spouse and things like that. But this recent decision that we'll come on to talk about in a moment talks about the fact that we have to make sure we view all-encompassing and make sure we apply the definition, the English definition of what a parent is, so that we can include a raft of different circumstances. And I think that the legislative framework is reflective of the fact that if we have an inclusive definition only, then it can't change with society. And I think that this is really what this case is about. Okay, so
are we saying then that having a very a definition will narrow the possibilities too much?
Yeah, possibly. I mean, the thing about family law is that no case is the same as the next one that's going to come across my desk. And if we have a definition that has to fit every case, then we can't allow for outliers. And we have to also remember that many different people fulfill parenting roles these days. We're not just talking about a parent who is a mother or a father. We're talking grandparents or aunts or uncles or friends. And so this issue of parentage, the presumptions that apply in the Act really are presumptions only, and the High Court and courts before it have continuously said that we need to be able to apply a broader range than what is allowable in the Family Law Act.
Yeah, I mean, there's no denying biology, but at the same time, if you have no involvement once that biology is provided, then someone who is there from the beginning and doing the work of a parent should have greater rights, shouldn't they?
Correct, and I think that is echoed in the Act. We don't just look at parentage in terms of this rigid framework. What we look at is, and what the court has said in recent cases, is that we have to look at the social environment of the upbringing of these children, and that might mean we have children who are spending lots of time with parents who may not be your traditional parents, a sperm donor, for example, but they are having big social impacts on these kids, and we can't deny their rights in terms of having an ability to make decisions or spend time with these kids. So
is it a case of almost apportioning parentage in a way, giving it a percentage?
Yeah, I mean, it's a case that we... the Family Law Act talks about what we call parental responsibility, which is the ability of people to make decisions, long-term decisions for children. So not what they eat for breakfast, but what school they go to, and are they raised under a religious practice. And I appreciate the point that you make, except we have to make sure that we can define who should be responsible for making these decisions.
Under the law, are we limited to two parents?
This case actually got close to determining this issue, this case of Mason and Parsons that was heard by the High Court 2 weeks ago. The High Court actually declined to comment as to whether or not we are defined only to two parents. So potentially in changes in social norms, and I think this case is a classic example of changes in social norms.
I'm sure many people are familiar with this case, but can you just go through the basic what happened in this case that makes it so interesting? What makes it most fascinating to me is that I guess this is the nature of law, but that even the courts didn't seem to agree.
Correct.
On what the legal definition of this was going to be.
Correct. This was a difficult case for all involved. It involved the circumstances of who we presume to be two friends, a woman and a man. Neither of them were in relationships at a time, and they both decided they wanted a child. And they entered into an arrangement where they used artificial conception technology to conceive a child. That child was born, and there was an agreement the whole way through that although Dad was a sperm donor in that sense, I think that colloquially we use, although he was a sperm donor, he was intended to have an ongoing relationship with this child, and he did. He made decisions for this child. He saw this child regularly, and he provided financially.
Was it an equal parenting role?
It presumably, and it's not sort of discussed in any great amount of detail in terms of the specific time that he was having, but it is shown that he had a significant role in the life of this child, and that was really echoed by the first decision made by the first court, being the Family Court of Australia, which was then overturned by appeal by the full court of the Family Court, which was then. The appeal was overturned by the Appeals Court in the High Court of Australia.
So that's not where it ended, though, is it? What happened was then the mother of the child went on to have a relationship with another woman, and
Correct.
it became a permanent relationship. So presumably it was the two women acting as parents to the child in the first instance.
Yes. And it was what actually precipitated the whole set of proceedings was the two women who went on to have another child. In fact, they wanted to relocate to New Zealand, and the father objected to that and sought orders from the court, the Family Court of Australia.
The father of the first child.
The father of the first child. Thank you. To prevent them from relocating, and it was determined by the first trial judge that yes, he was a parent, albeit didn't fall under the parameters of the Act because there's no definition, as you pointed out. But he met this usual social definition, the English language definition, and the court has said, the initial judge and then the appeals court from the High Court, they've both said that we have to make sure we can apply this English language version of what it means to be a parent.
Given that lots of people have step situations, can I ask about the role of the new partner, so the second woman in this? Because she's in a relationship, she's bringing this child up with the biological mother of the child, with the father's active involvement. What role or legal responsibility does she have?
The court actually...
Because in different configurations, that would be reflected in many households.
Yeah, absolutely. And we often will see applications in the family law courts of people who are not mum or dad that might be a step parent from a long-term relationship who perhaps may have brought up a child.
Yes.
And those applications are allowable under the Act, and to make sure that prominent people in children's lives can continue to have a role, and whether or not they can have parenting rights in terms of decision making is entirely dependent on the facts of an individual case. But certainly, if a stepmother has raised a child for 10 years, the court is very likely going to say, well, this person is an important person in this child's life. They should continue to have a role in that child's life.
Let's talk about, there are so many issues with this, aren't there? And you might be listening to this and have a question with it. We're asking the question, who is a parent? What makes a legal definition of a parent? Because at the moment, we actually don't have a legal definition of a parent. This is a sort of fluid and flexible term depending on the circumstances. And you might have some questions related to some sticky situations. 1300 222 891. You can also text us on 0467 922 891. You can throw these questions at Troy Roulstone, Associate Solicitor from Anderson Solicitors, because he's an expert in this area, in what for many people would be a grey area, because as you say, it changes, doesn't it?
Absolutely.
So, I mean, this raises the issue. If you are a sperm donor with no intention of being involved on a day-to-day level with any child that sperm donation produces, and I guess we could add now an egg donor, because we're talking more and more about the possibility of an egg donation bank. What if you change your mind 20 years down the track? I mean, you make a donation when you're young and not thinking about it too much. And then, in your 40s, maybe you don't have children. Maybe you're being wistful. Maybe you're thinking what the product of this donation might have been. And suddenly you want to be involved. Is there any kind of biological parental rights at that point?
There are presumptions in a state-based legislation in South Australia. We have the Family Relationships Act that talks about presumptions of parentage in terms of artificial conception. And of course, Mason and Parsons is a federal case, and now I'm talking about state-based laws. But those presumptions are generally against a sperm donor in that traditional sense. But sort of responding to your question, is a sperm donor who changes his mind 20 years down the track going to have any parental rights? There's not necessarily anything that stops him from being able to try to pursue a relationship with a child who may have come from his donation, but that doesn't necessarily mean he's going to be a parent or have parental rights, and that's the important distinction, I think.
I guess 20 years on, they're then an adult of their own, but even if it was 10 years on,
Correct.
Where they're still perhaps under guardianship of some sort.
Yes, but the point is that they may not, and they likely would not, be able to fulfil this definition, I think, that the family court and the first judge of the family court and the High Court have said. They're not going to fall into this definition of what a parent is in terms of socially. They won't fall into the definition under Section 60H of the Family Law Act, and they're not going to fall into this social sense because they haven't had involvement. But that doesn't mean they can't try to spend time or have a relationship.
Yeah. What about if you are a donor as such, but you're a known donor, not an unknown donor? You are doing this to help other people have children, and you are standing back. You're not planning to be involved in the relationship. But suddenly those parents are perhaps making decisions that you're not that happy with about that child. You have some biological skin in the game, so to speak, but not deliberately intending to be involved, but don't want to see this child being hurt in your eyes. It feels so grey to me.
Yeah, and there's no easy answer, and that's the thing about family law, is that it's not a cookie cutter set of laws that we can apply. We have to apply the circumstances of each individual case, and the High Court and the Family Court have said that time and time again. But in circumstances where someone perhaps has had some minimal involvement with a child, maybe they donated sperm to a friend who's then subsequently had a child, that person isn't precluded from being able to make this application because they might be a special someone involved in this child's life, albeit not a parent. Whether or not they would be able to get a parenting order in that sense is, again, another question. It will depend on the circumstances. But I would say that they're not precluded from doing so.
Come to a decision in a court situation about this, what are the questions that you are weighing up as to whether someone does have that right to be involved?
Sure. There's really two initial questions a court has to ask, and that is, who should we assign parental responsibility to? And there's a presumption at law that parents have equal shared parental responsibility. They should jointly make decisions. But the second question is, how much time should these children be spending with either of these parents? And that really comes down to this paramountcy principle that is outlined in the Act, that is, what is in the child's best interest. And that is assessed by looking at things like what views are expressed by a child, whether the parents are able to provide financially and socially and psychologically for children, to what extent parents have not been involved in a child's life. And so we have to look at a set of social circumstances that are outlined in the Act. And in that section of the Family Law Act, there's a, whatever else the court feels is relevant. And so the court has this broad range of considerations that they can apply, and they have to apply them to each case individually. And that's what I mean when I say the laws aren't necessarily going to be applied the same way in each case. It is not a cookie-cutter piece of legislation.
Justin's given us a ring. Troy Roulstone from Anderson Solicitors is listening to you, Justin.
Hi, Justin.
Hey, guys. How's it going?
Good, thanks.
Good, thank you.
That's good. So basically my question, I'm a stepdad. I've been married to my wife for about 3 years. We were together for about 5 years before that. The biological father wasn't in the mix initially. But sort of when we decided to get married, he decided to step up. And I guess my question is, if something were to happen to my wife, would I have to fight him for custody in the courts? How does it work that way?
The likelihood is, Justin, is that, and depending on your circumstances at the time, but the likelihood is that very possibly yes. You would be, in my view, based on the limited information that I've got, you would be someone who is able to make an application, but presumably the biological father's name's on that birth certificate, and you would then need to be proving to a court that you are the best person to be looking after this child or children, but you would certainly have a fight on your hands, in my view.
Okay, so let's say something were to, obviously the unforeseen happens, let's say my wife gets into a car accident and sadly passes away. Would the child then automatically go to him and I have to initiate the fight process? Or how would it work?
Not necessarily. I mean, if that was to happen, you should definitely get some advice at the time. But
because I understand where Justin's coming from then, because you'd be uprooting the child from the home that they know.
Yep.
Even though the mum's gone.
Absolutely. And that's why, as is always the case, I always say to clients who come through my office at Anderson's, I always say to them, it is good that you've got advice early, and it's important to make sure that if something was to happen, that you get advice immediately. But probably what's more important is that there are other things that you are able to do in terms of, setting up a will that has a testamentary guardian clause from your wife that is to indicate what is to happen, and therefore her intentions are recorded. But it would be the case that if you walked through my door, I'd be saying to you to file an application immediately.
Yeah. And like you said, I guess you've got to build your case as to why it might be better for that child to stay or go.
Exactly.
Stay or come, depending on what your perspective is. And that may be different depending on how much level of involvement you as a parent has that. Has it ever been decided that a child has more than two parents? I think I asked this question vaguely before, but, can you have 3 or 4 parents, particularly if biological parents have gone off and partnered with others?
That's not a question that has been answered. This case goes so close to discussing the issue, and then the High Court has essentially said, but we don't need to decide it because it's not relevant on this occasion. Right. So you could try to read between the lines and say, well, the High Court's perhaps suggesting that that's a possibility, but I wouldn't take it any further than that. I'd be specifically noting that that hasn't been determined.
Still on the step parent issue, one of our texters at 28 minutes past 2 is saying, how long does a person living with someone in South Australia have to be before they're considered a step parent?
Again, it would depend on the entire social circumstances.
Okay, so we're looking at how much involvement
Correct.
You have, what
Yes.
sort of level of decision-making you do. Even you'd have to demonstrate how hands-on you are.
Exactly, and remember, this is a matter of discussing the 2 different questions, the first one being decision-making, parental responsibility versus time, how much time someone spends. These people living for a couple of years who've had lots of involvement would probably get some time, but they wouldn't necessarily get an order for parental responsibility.
So it's not just about whose names are on the birth certificate then? No,
it's far from the case that is what we should focus on.
When it comes to the specific definition of a parent, then, do you believe that we are any closer to having that in words defined?
Look, there have been lots of proposed changes by the federal government to the Family Law Act. They're looking at amalgamating the courts, for example. So we have the Federal Circuit Court and the Family Court, and they're looking at amalgamating that into one court. And part of that process has been a review of lots of different aspects of the Family Law Act. And this may be a decision that elicits a response from the federal government to look at inserting a definition. However, I'm of the view that it's intentionally supposed to be broad so that changes in social norms can be incorporated as cases come through the door, because lots of statutory definitions of parentage or presumptions would exclude 2 men from being able to, in a relationship, from being parents. And of course, in 2017, as of 2017, we have marriage equality, and that's what I mean. If we look at the significant changes in social norms, I'm not quite sure that it would be a great thing in terms of justice for parents coming through the door, to insert a definition. I think that would be problematic.
I'm thinking about surrogacy now too, because the intention there is to simply create the child not to be involved in it, presumably, the child's life. But again, maybe that intention changes if you're not happy with how things are going.
Exactly. And I think that, any type of artificial conception through surrogacy or, two parents who are having problems conceiving through IVF, or I think that we are seeing big changes because of the frequency that these things are now coming to light.
I know that's where the complication comes, because it's not easily defined. But, I mean, surely there are as many grey areas in a situation where, people have children the normal way and but one is not choosing to be active, whether it be the mum or the dad, and then chooses to come back into their lives. I mean, it might be a role then where a grandparent or a sister or a brother then becomes a parent figure.
Correct. And in my time practicing, I've seen, adult sisters come along and file applications for their infant siblings. It is, again, a demonstration of social norms changing. But if we defined it in the Act, that would cause problems for these people coming forward, unless we were then to specifically include people. But who knows who else we're going to have to include in 20 years' time.
I mean, do you have a biological right to be described as the parent if you have had nothing to do with that child?
Do you have a biological right?
Well, I mean, you have a legal right, but if
Yes.
you're the biological parent, and you conceive the normal way or the natural way, but you chose not to have any involvement, and 12 years later you decide to come back and be involved in the child's life.
Yeah, I mean, I think in a case like that, again, depending on the circumstances, if you were to front up at a court and say, my child's now 12, I haven't seen him or her for 12 years, but now I want some involvement, a court's going to look at it very sceptically, I can tell you that. Whether or not he or she would be granted any rights in terms of parental responsibility, so decision-making, that's a pretty serious question to ask, and I think the answer is probably no. And then the next question is, well, how much time should this child spend? And we go through a raft of different evidentiary inquiries. We get reports from psychologists and counsellors looking at the social circumstances and the possible impact on these kids, inserting potentially a stranger into their lives to then, have to potentially call them mum or dad. Yeah. So, it's a difficult social question.
And I guess from what you're saying, that, my surprise that there is no legal definition of a parent, if we did have that, maybe it would make things more complicated because it rules out so many situations.
Absolutely. I think that it is genuinely an acknowledgement that families take all shapes and sizes, and that's going to continue to be the case.
We're going to have to wrap up, but Chris from Clarendon is asking, what rights do the children have? At what age can they have an opinion about, I guess, who they choose to see as their parent?
Yeah, look, very quickly, it's an issue of how mature this child is to have proper views and how much weight we have to give to their views. But strictly speaking, all children, so people under the age of 18, are bound by orders of the court. It's not practically how it comes out because we have to give their views weight, and if they've expressed a particular view, then the court has to take that into account.
And finally, Karen's given us a call. Troy Roulstone, listening to you, Karen.
Hi Troy, hi Sonia. I just had a question. I'm in a relationship with another woman. She has children, but from a previous relationship. The biological father, has nothing to do with the children. However, if something happened to her, I'm assuming I'd have a bit of a fight on my hands to keep them with me.
Very, very possibly. I think it would be the case that, again, you'd need to get some pretty quick advice. But if Dad has no involvement now and you've had significant involvement for a number of years, you are definitely a prime person to apply to a court to get parenting orders. And whether or not you would be sort of in advance of the biological father is a question to be determined on the context. But certainly you'd be a strong applicant.
Yeah. Karen, thanks for your call. And Troy, look, I think all we've determined from this is that there are many grey areas, and as you said, to be determined on an individual circumstances.
Absolutely.